Resolving a child support case can take a very long time indeed. Whether it's a child support case that's being heard in court or a child support case being heard at the Child Support Agency, which is called a change of assessment, the process can seem to take forever. Is there anything a payer of child support can do in the meantime? Does he or she merely have to continue paying child support whilst the process that has been commenced continues? And the answer is no. A payer of child support who wants to put on hold his or her payment of child support can bring an application in the court for what is called a child support stay order. Now, the law on point is to be found in the Child Support Registration and Collection Act of 1988, in particular Section 111C of that Act. Now, regular viewers of this channel will realise that the Act I've just cited, the Registration and Collection Act, is different to the Act that I normally discuss here, which is the Child Support Assessment Act. If you want a child support stay order and you want to have a look at the applicable Act, you want the Child Support Registration and Collection Act, not the Child Support Assessment Act. But when you have a look at Section 111C of the Child Support Registration and Collection Act, you'll see it's very vague. It talks in general about what the law is. To fully understand it, one needs to delve into the case law that has been determined on Section 111C. There are many family law cases which have been determined in the family court, specifically looking at Section 111C. But my favourite case, the one I had most success with when I was a lawyer, is a decision of the Victorian Supreme Court called Salanti Properties and Callis. It's reported in the 1991 Volume 2 report of the Victorian Reports. And for those of you who have access to a law library, you will see that case is reported at page 653. Now, in relation to law reports, I like the old-fashioned way of doing it. I like a leather-bound hard copy book to read, put it on my desk, I can look at it, and I find that a much easier process than going online. But for those of you who don't have access to a law library, it's possible to read most of the cases I discuss online. There's a website, ostley.edu.au, and it's free, it's easily accessible, and I would encourage any of you having a look at these cases but not having the access to a proper hard copy law library to go there and have a look at the cases. So what does Salanti Properties and Callis tell us about stay orders? It says principally two things. Point one, applications for stay orders are interlocutory applications. Okay, they're made by the court in a hurry, quickly. There's been no proper analysis by the court of the fundamental case. Okay, very short affidavits are filed, and the court hasn't had the opportunity to delve into the detailed nuances of the case. Detailed pleadings haven't been exchanged between the parties, so the court it's kind of flying half blind. And what that means in reality is that the bar set for these things is relatively low. Okay, it's relatively easy to get a stay order. You don't have to jump over a bar this high. A bar that high is the kind of thing that the court sets. Point two, in order to get a stay order, it's important that a payer of child support demonstrate to the court that if he or she were to continue to have to pay child support and he or she was successful in the substantive case, it's going to be very difficult for the payer to get back any monies that he or she has paid to the other side in the interim. So ideally you would look into the payer's finances and say, look, they're such that if I am ultimately successful in this case, the payee's got no asset base or no income base to be able to pay me back the child support that I would have overpaid. I'm Simon Bacon. I was a child support lawyer for 35 years, and if you want to know more about stay orders, have a look at my website, childsupportlawyers.com.au.